what I want to do is to address what I think of as a hard question about the value of diversity as it relates to the constitutional value of equality. As history has shown, right, within certain populations, diversity isn't something that just happens, right? It doesn't just fall out of the sky. The reality seems to be that sometimes in order for a community to become diverse, for example, a community in a selective university student body, in order for a community to become diverse, certain affirmative measures have to be taken. For example, you might have to give certain underrepresented populations a little bit of a boost, a little bit of a leg up, maybe even a little bit of a preference in admissions, right, in order to make diversity happen. So the hard question is this: is it consistent with the constitutional value of equality to give some people a preference in order to make a particular community more diverse? How does the Constitution's mandate of equality really leave any room for that kind of thinking? How does the Constitution's mandate of equal treatment leave any room for contemporary arguments in favor of promoting diversity? Doesn't equality mean that the law has to be colorblind, right? The competing values of racial diversity and colorblindness are both, I would say, those concepts are both manifestations of the Supreme Court's attempts at various points in its history to flesh out the meaning of this abstract concept of equal protection of the laws. In 1964, a Civil Rights Act is passed, and throughout the 1970s, the courts were busy implementing all these new legislations in the many litigations that the Civil Rights Act spawned. And so to be sure, all these developments allowed for many opportunities to open up for minorities that had never been available before, right? That minorities would never have even sniffed before. But at the same time, right, the reality was not quite so bright, right? There was a big gap between theory, right, the formal equality of opportunity, and actual results. Right? For minorities, it was obvious that real measurable progress in achieving substantive economic equality was very, very slow to come. Zuma had 40 years from that time, 1964 to 2003, when we as a nation were still struggling with racial inequality as a fact of life in this country. By then, many public universities, perhaps feeling that maybe they had an important role to play in helping to alleviate this problem, many universities had implemented affirmative action in their admissions policies, right? They gave preferential treatment to minority applicants. So the problem, of course, right, is when you're talking about a selective institution, for every extra student that you decide to admit, that leaves one less seat in the class for everybody else, right? So there's a student, a white woman who applied to the University of Michigan Law School who gets rejected, and she complains that, I'm just as good as some of the minority, or better than some of the minority students who were admitted with a preference. So she sues Michigan, and the case ends up going to the Supreme Court. And now the court says in a 5-4 decision written by Justice O'Connor and joined by Justice Souter, the court says, it's true that in general, racial classifications have to be scrutinized very strictly. But, the court says, in the context of higher education, the constitutional concept of equality allows giving a slight preference to racial minorities in the admissions process. Why? How is this possible? The answer, again, lies in the relevant social context, the relevant social facts. Our institutions of higher education play a critical role, right, in preparing our youth to be the leaders, teachers, employers, public citizens of tomorrow. Because in a racially diverse community, as the Supreme Court, as Justice O'Connor says in her opinion, cross-racial understanding is maximized, racial stereotypes are broken down, right? Diversity in the student body helps students internalize the values of equality that they will need, right, once they get out into the world and become effective, responsible citizens in a racially heterogeneous society. So some argue that racial diversity continues to be a compelling interest, right, in the context of higher education that justifies the limited use of racial preferences. The argument on the other side, right, that we're all familiar with, seeks a return to colorblindness. I'm not going to try to resolve the conflict. I will close with a couple of observations. First, the story of how diversity serves the value of constitutional equality is one that's highly dependent on social context. Right? Using preferences to create diversity in the name of equality really only makes sense when we are attentive to the context of higher education, right? The idea of giving a preference to create equality only makes sense when we think about the mission of higher education and the social effects of putting certain groups of people in a selective educational context. Outside of those, specific factual points of context, the idea of using race preferences in the name of equality will seem, paradoxical or irrational. But as I hope you can see, the idea of colorblindness in the social context of higher education today, I think has a much different set of resonances than the idea of colorblindness in the time of Jim Crow.